Hello everybody, I'm George from Ireland, so welcome back to my English law channel. So carrying on with the contract law, and I was looking at consideration, but now I want to consider part payment of a debt. So there was that decision in Folks and Beer 1884 that said that usually if you have some obligations and something additional is done, for instance paying your debt ahead of time or paying in kind rather than cash, then the whole debt can be discharged. That is going along in Pinnell's case, 1602. But in Folks and Beer, it was said that if you pay less than is due, and or it's a late payment, then that will never be proper consideration for the rest of the debt to be written off. In Folks and Beer, the House of Lords was loath to say this, but nevertheless found the implication of the rule in Pinnell's case is that Mrs. Beer, she promised to forgive the person interest on the judgment debt so long as Dr. Folks paid off the principal of his debt by instalments. But anyway, this promise was unenforceable, it was found. So the common law rule has been increasingly unpopular in recent years, and people who often get around with using the doctrine of promissory estoppel. Remember, that's an equitable doctrine, therefore one which is discretionary. The court could choose to disapply promissory estoppel, even if it was pertinent in that case. So another qualification in the Williams against Roffey case, and the Court of Appeal applied this in MWB Business Exchange Limited against Rock Advertising Limited in 2016, because in numerous situations there'll be a practical benefit accruing to the creditor to get some of the debt rather than receiving nothing at all. So in that situation, an agreement to accept less of the full debt will be regarded as consideration, and therefore the contract is a proper one. So in the MWB case, the Court of Appeal seemed to broaden the area where this practical benefit would be held to be applicable, to go beyond Williams and Roffey, because in that decision, a lot of people have disagreed with it. There was South Caribbean Trading Limited, or SCT as it's called, SCT against Trafigura Bahia BV in 2005. A judge named Coleman said the decision went against the centuries-old rule that consideration must move from the promisee. That's time-honoured. Anyway, let's look at past consideration. One of the other rules is that consideration has to be given after the promise, or indeed at the time. It can't be something that's already done, because past consideration is no consideration. That promise will then be unenforceable, something which is contingent upon past consideration. So Ray McArdle was a case in 1951. It's called Ray McArdle because there was only one party that the House of Lords had to rule on this. So the claimant, or plaintiff as he then was, had done some refurbishment in the house that he shared with his siblings. And they had a beneficial interest in it. So he'd asked them to pay something to cover at least part of the costs, and they promised to do so. But then the court found that this promise was unenforceable because the promisee had already done the work, right? So there was no consideration coming from him. So the plaintiff could only say, well, look at the work I've done. Yes, but that was finished before they made this promise. Anyway, there are certain exceptions to this rule, saying past consideration is invalid. And there are situations in which completed acts will be considered proper consideration. Pao On against Lau Yu Long, 1979, is a key case, that Hong Kong case. So Lord Scarman said there are three conditions, and if fulfilled, then past consideration is proper consideration. One, the act that is consideration must have been done because the promiser asked for it to be done. Lampley against Braithwaite, 1615, is a case of that. Two, the parties must have realised that the work was going to have to be paid for in some manner, whether in cash, kind, services, forbearance, whatever. Ray Case's Patents, 1892, is an example of that. And three, the promise must have been a legally enforceable promise if it had been made in advance of the consideration. So anyway, the second condition is tricky. How can we be sure that they realised that the work was going to have to be paid for, even though they didn't actually say it? So that's often where they fall down, claimants. Okay, so just going on a little bit further onto promissory estoppel. So this is an equitable doctrine, and this means you modify a contract which is already extant. Under classic common law, a contractual modification was only binding if if there was a new contract that was made. So parties would have to end their current agreement and set up a new contract, and therefore there would be mutuality. All right, so this was a burdensome way of dealing with it, and it was quite common for parties to say, well, the situation has changed, the price has gone up or down, and therefore we need to change it a bit. So promissory estoppel is found in Hughes against Metropolitan Railways, but it's gone further. Judge Denning, or Lord Denning as he later became, and perhaps the most celebrated jurist of the 20th century in the United Kingdom, who lived from 1899 to 1999. His leading case on this was Central London Property Trust Limited against High Trees House Limited, 1947. You can see the video filmed right outside the building. Collier against P and M.J. Wright Holdings Limited, 2007, is a case where Lord Justice Arden sat on that one. So he went further than the High Trees case. So High Trees House, to reiterate, is a case about a block of flats in London just by Clapham Common, and in the Second World War it was very difficult to get tenants, so the owners of High Tree House, Central London Property Trust, they agreed to reduce the rent. They were renting it to High Trees House Limited, who then sublet it to the tenants. So at the end of the war, the Central London Property Trust said, well, we let you off half the rent, and we changed our mind. We demand all that back rent. And the High Trees House said, no, you can't do that. And the Central Property Trust said, oh, yes, we can, because you didn't give us any consideration for it. Therefore, that promise is not binding upon us. Well, Lord Denning said it was promissory estoppel. It would be unconscionable to permit these people to renege on their promise and get away with it. So he said there's promissory estoppel will operate as a doctrine where a promise was intending to be binding, it was intended to be acted upon, and was in fact acted upon, and is binding insofar as terms properly apply. So so common law has long accepted a doctrine of estoppel by representation. So an estoppel only comes about if it's a statement of fact rather than a promise to do something in future. Jordan against Money, 1854 is a case. There's the notion of waiver, which is accepted by both common law and equity as a way certain rights can be forborne. Say, okay, I won't enforce my rights, and but then the rights can be got back if you give notice. Hughes against Metropolitan Railway, 1877, is an example of that, about this informal contract to supply coal. There was no written contract, and there've been over several years, Hughes has been selling coal to Metropolitan Railway, and then they say, well, let's put this on paper, so Hughes does, and puts the name of an arbitrator in case of any dispute. It's given to Metropolitan Railway. I don't feel they even sign it, they put it in a drawer. Hughes goes on selling coal to them, they carry on accepting the coal, and after a few years, Metropolitan Railway say, well, this contract doesn't operate. And he said, well, wait a second, it does, and they wouldn't accept the arbitrator, but they'd accepted it by conduct, by continuing to purchase coal from him. So Lord Denning, he looked to Hughes against Metropolitan Railway a great deal when he was formulating his judgment on High Trees House. There's also the idea of waiver, and this wasn't previously regarded as applicable to part payment of debts. So a waiver has now been more or less absorbed by promissory estoppel. So what are the needs of promissory estoppel, and what are the restrictions of promissory estoppel? So promissory estoppel is something that you'll find in a number of key cases, but it does have strict confines. So perhaps the best précis of it is by Lord Justice Kitchen in NW Business Exchange Limited against Rock Advertising, 2016. It went all the way to the Supreme Court, that one. So in that case, this is what was said by Lord Justice Kitchen. Drawing the threads together, it seems to me that all of these cases are best understood as illustrations of the broad principle that if one party to a contract makes a promise that other legal rights under the contract will not be enforced or will be suspended, and the other party in some way relies upon that promise, and whether by altering his position in any way, then the party who might otherwise enforce those rights will not be permitted to do so, where it would be inequitable, having regard to all the circumstances. close quotation. And that's the operative phrase at the end, having regard to all the circumstances. And you'll often find that in contracts or legal judgments. So the court could look at all the circumstances and decide, no, actually, well, despite this, we are going to say he is allowed to enforce his legal rights, the ones he promised not to enforce. So, okay, so a number of conditions are to be satisfied. First of all, there must be a clear and unequivocal promise. Okay, it can't be something that's vague. Like high trees, it was absolutely explicit what they're talking about. It's very lucid, and Hughes and Metropolitan Railway as well. So anyway, you have to be clear about it. Kim against Chasewood Park Residence 2013 is an example of it. Closegate Hotel Development Durban Limited against McLean 2013 is another. All right, another condition is the need for reliance. The party must have relied upon the promise made. They must have done something, spent more money, stayed longer, purchased more, whatever it is. Because then once they've relied on it, not necessarily to their detriment, that means that it would be unfair and indeed unconscionable to get away with someone breaking that promise upon which people have actually relied. So W.J. Allen and Company against El Nasser is a bit different. And Denning said it doesn't have to be to their detriment, and that was the case. We said no, even if it's not to their detriment, it still makes this a binding promise. Reliance is enough, and it would be inequitable to allow a promiser to renege on his promise. The post-Chase in 1982 is a case about that. Another part of promissory estoppel is a shield, not a sword. All right, it's got to be about an extant relationship. Coombe and Coombe, 1851 is this. The wife, she sought to sue her husband because he was meant to pay her some maintenance. She hadn't given any consideration for that. So at first instance, she won a case on the basis of promissory estoppel. It went on to the Court of Appeal, and Lord Denning sat on the case, and he said that promissory estoppel couldn't be the cause of action. Is to provide for the promisee when the promisor tries to break his promise. Because, the lessees, again, were given protection, High Trees House, against them, those people claiming back rent. Anyway, Lord Denning said this in that he said, consideration remains a cardinal necessity, the formation of contract, though not of its modification or discharge, close quotation. So consideration is not necessary to change an existing contract, only to set up a new contract. So courts usually don't go further on promissory estoppel. Examples of they haven't allowed it are Baird Textile Holdings Limited against Marks and Spencer's PLC, or if you go to Australia, Walton Stores Interstate Limited against Marr, 1988. Another point is it must be inequitable to allow the promisor to renege on his promise. There's another condition to be satisfied, and that's to do with the equitable doctrine of waiver. So the judge, remember, he is not compelled to apply this because he's got discretion here. So the judge can decide, is it fair to allow someone to break their promise? It may be to say that it is fair to allow someone to break his promise. He looks at the whole situation. D&C Builders against Rees, 1966, an example of this. The builders promised to accept part payment as a way to get some money, and the debt would then be written off, the remainder. But there was no promissory estoppel because the debtor had exploited the fact he knew the builders were in a very bad situation. They really needed the cash flow. He had them over a barrel. So this was a sharp practice. So promissory estoppel didn't operate. Remember, he who comes to equity must come with clean hands. If you've done anything illegal or guilty of sharp practice, then equity shall not assist you. So the post-chaser shows that even if there's no impropriety, it could be that it's okay to break the promise because a promise was made, and then the other promise, they rescinded the promise very quickly, and so the promisee hadn't actually changed his position, so they didn't suffer at all from it. Okay, another thing is this is a suspensory doctrine. This is the fourth condition. So it's about modification of contracts, and it's usually not of permanent effect. Remember, in High Trees House, it was only for as long as the war lasted the rent was reduced by half. And once the war was over, they had to pay the full rent, which High Trees House Limited did without complaint. So Tool Metal Manufacturing Company Limited against Tungsten Electric Company Limited, 1955 is a case about this. So the doctrine is suspensory. That means whilst it's going on, whilst it's working, promissory estoppel, you can extinguish rights. Sometimes it can delay the rights being enforced. In tool metal manufacturing company, it was accepted that lower payments, whilst promissory estoppel was working, would carry on. However, the promisor couldn't recover the balance when due under the original contract because he'd waived some of that money. So in NWB Business Exchange Limited against Rock Advertising 2016, the judge said obiter dicta that if a creditor accepts part payment of the debt by instalments, then that doesn't automatically mean that the creditor can't claim the balance of any instalment in respect of a payment which has been made. That's enough. Toodaloo.